Welcome back to Hardball. President Obama made clear, of course, in that speech that he opposed the Supreme Court's ruling in the case known as Citizens United. And now the group Common Cause is pushing for an investigation into whether Supreme Court Justice Clarence Thomas had a conflict of interest in deciding that case. They've asked the Attorney General to investigate. Orrin Pearson is Vice President of Common Cause. He's pushing for that investigation. Former FEC official, or chairman rather, Bradley Smith also joins us. He says Common Cause is wrong. So we have both sides here. Orrin, let me ask you this question. Did Justice Thomas take money or gain any kind of perquisite or any kind of favor from a group that had an interest before a Supreme Court decision? Did he take any money or get anything from the Koch brothers or anybody that had an interest in a Supreme Court decision?
Well, no, Justice Thomas didn't take any money, and that isn't the standard.
Did he get any benefits from them? No, let me answer my question. Did he take anything? Because that's usually what we look for in conflict of interest. Did he take anything? Did he get anything? Did he get any favors, any benefits at all that might have influenced the decision that he made or voted on with regard to Citizens United?
No, he didn't. His wife had a financial interest that we've raised in this matter, and he had, and there's an appearance of conflict, which is actually the standard. In order to recuse a judge, you don't need a judge to receive a financial benefit.
Okay, then what's the appearance? What's the appearance? Because I didn't know about this meeting out there, but you're saying because he went to a meeting of the Federalist Society, and the Federalist Society is all over the place in this town here. I didn't know they were, a discredited organization. They're a conservative legal society. You're saying to appear before the Federalist Society is a conflict of interest.
No, it's not appearing before the Federalist Society. We're raising questions about whether he attended a closed-door political strategy and fundraising session by Koch Industries and had his way paid for by the Federalist Societies.
Oh, I see. And the Federalist Society paid his way. In other words, this was a pass-through to get him to go to a Koch brothers event. Is that what you're saying?
Well, that's what it appears to be. Now, we raised a question because Koch Industries put out a letter touting the fact that their past events had featured Justice Thomas and Scalia. Right. And when we raised those questions, the court put out an official statement saying, no, they spoke at a Federalist Society dinner sponsored by the Kochs, and Justice Thomas just dropped by. Well, if he just dropped by, then we went back and looked at his disclosure forms, and he was paid. He had his accommodations and meals paid for in sunny Palm Springs for 4 days.
By the Federalist Society.
Which is it? Did he?
No. I know you threw in the sunny. I know you threw in the sunny part to slant this a bit. I just want to get the facts. It's not funny.
Yeah.
It's not funny. You're accusing this guy of conflict of interest because he went to a Federal Society meeting. And I just want to know if has any Associate Justice or any Supreme Court or federal judge ever spoken before a Common Cause event? To your knowledge.
Well, no, I haven't, but you're misunderstanding what the concern is.
Has a Supreme Court Justice ever spoken to a Common Cause event at all? So what are the groups that you don't want Supreme Court Justice to speak to?
This isn't about the Federalist Society. We're not challenging a Federalist Society event. What we are raising a question about is whether he attended a political strategy and fundraising closed-door session with Koch Industries.
Do you know if he did?
The judges appear.
Did he?
I'm
just asking. Are you accusing him of doing that?
Society events all the time.
Are you accusing him of going before, involving himself in conservative strategy that would affect the Supreme Court ruling? Conservative strategy.
It appears that Koch Industries has said that he attended. His disclosure forms show him in Palm Springs for 4 days on days.
Yes, but he was at a Federal Society meeting. Okay, it's a Federal Society meeting. They paid for his trip out there. You would say he stayed a few extra days. He shouldn't have. Okay, he should have stayed maybe a day or two, 2 nights at the most. He got 3 nights or 4 nights. Fine. That's your point. Now the question is, do you know if he participated in a strategy meeting yourself? Would you swear to the fact that he was at a strategy meeting with the Koch brothers? I don't think they should have anything to do with the Koch brothers.
No,
are you saying he ever sat in a strategy meeting with them? Well, what are you saying?
No, we don't. We don't. We're asking the question. We ask that we don't have the information.
Okay, fine.
We are asking the question. We ask the Justice Department to investigate. Yeah.
Let's hear from the other gentleman.
Well, Chris.
Bradley Smith. Let me hear Ms. Smith, your view.
Chris, I think it shows the sort of absurdity here. I mean, there are legitimate interest about how far justices should go in making speeches. Justice Ginsburg does it, Justice Breyer does it, Scalia does it, Thomas does it, and some people would say they should all take the approach of Justice Souter and not do anything. But Justice Thomas has been on the Supreme Court for over 20 years. He has voted to strike down as unconstitutional every single campaign finance case that has come before him in that time. Nobody, I think, seriously thinks his decision in Citizens United has anything to do with, him spoken to a group of people who meet to talk about political issues.
Your response to that, Orrin? Did you say it affects his decision?
Yeah, I think that if a liberal justice had attended a Democracy Alliance strategy and political fundraising session,
but you don't
the
know
House
he
Republicans
attended.
would be up in arms.
But you don't know. I just ask you. I just want you to make your charge here. Are you charging Associate Justice with sitting in on a strategy session?
I am raising the question based on the Koch Industries' own statement that he was featured at a strategy session, and by his disclosure forms that suggest that he was there, and asking the court to provide the American public with a clear explanation of whether he was there or not.
And he was at a Koch brothers event, or was he at a Federalist Society event or a Koch brothers event?
Exactly, and
I'm asking the question,
Society keeps
was he at a Federalist Society event, which he clearly put on his form? It's all on the form. 4 days paid for by the Federalist Society. He's not denying it. He said he was there. It's all on the record. He did that. You're saying it was something different. He was at a Koch brothers event. And it was a strategy session.
There's a strong likelihood that it was. Yeah.
Okay, and that's in the New York Times.
There's no record of a Federalist Society event. So.
Okay. Mr. Smith?
Well, Chris, let me take this further, of course, to give an idea of the nature of Common Cause's complaint. They've got several counts, and one of the alleged counts, so to speak, is that Clarence Thomas is on the Supreme Court. His wife is Ginny Thomas. Ginny Thomas worked for a group called Liberty Central. Liberty Central has a board. On the board sits a man named Matt Schlapke. Matt Schlapke runs a political consulting business. One of his many clients has at times been the Koch brothers. The Koch brothers used the constitutional liberties that the court affirmed in Citizens United, and some people disagree with that decision, but the court just said this liberties apply to millions of Americans, and the Koch brothers then used that liberty in the last campaign. From that, Common Cause wants us to hold that Justice Clarence Thomas should be disqualified. We follow that circle all the way back. I just don't think it passes the seriousness test, and I think it's just a partisan effort to sort of discredit the court and discredit that decision, and it's the kind of thing that historically liberals have sort of championed, is the independence of the court. We shouldn't let conservatives or others make these kind of broadside attacks on them, and here I think Common Cause is engaging in that kind of tactic. This is not to excuse what conservatives may have done in the past. I tend to agree with the old standard that there's no question of bias here, and this complaint is really just to gain attention and to try to discredit the court.
Okay, thank you, Orrin Pearson. Thank you, Bradley Smith. Up next,